Hello and welcome to the second semifinal round for the December 2025 International Mock Trial Contest. We begin with 38 teams from across the world, and we're down to the final four. We have an esteemed judging panel for the semifinal. We'll go through them step by step, beginning with Karen.
Hi, I'm Karen. I'm currently a first year in college. I used to do mock trial a lot in high school. I'm also an IMT alumni, so I know how much work you guys put in, and I'm really excited to see this round.
Next, William.
Hi guys, I'm William, senior in college, college level mock trial competitor, also did mock trial in high school. Great to be here and good luck to everyone.
Last but not least, your presiding judge, Stephen Noodleman.
They save the oldest for last. My name is Stephen Noodleman. I am a partner at a 100-lawyer firm based in central New Jersey and have been practicing for close to 30 years. I've not participated in mock trial, but I've judged college and high school mock trial, including this tournament, for a good number of years. And I'm looking forward to it, and good luck to everybody.
Best luck to both teams. Judge Noodleman, let's get the show on the road.
Okay, let's call a case of the estate of Arthur Henley versus Elias Hornby. My name is Judge Stephen Noodleman. Scoring judges, look to the two buttons on the lower left of your screen. Remember to keep your audio off, video on until the end of trial. You should also have your video set to hide all non-video participants. Okay, whoever is keeping time for this trial, ideally a volunteer from both teams, please identify yourself. Do we have a timekeeper?
Good evening, Your Honor. I'm David Leonel, and I will be the defense timekeeper for this case.
Okay, is there a plaintiff timekeeper?
Good afternoon, Judge. I will be the timekeeper for the prosecution.
Terrific. Okay, each side has 1 hour to prepare the case before performing in an abridged format, an opening, direct, a cross, and a closing. All these things together may not exceed 30 minutes per side. All right, let's have the attorneys enter their appearances, please.
Good evening, Your Honor. My name is Coco Jiang, and alongside my co-counsel, Ishaan Sachdeva,
Good evening, Your Honor.
Good
we
evening.
represent the estate of Arthur Henley. At this time, may our witnesses please introduce themselves?
Sure.
Good evening, Your Honor. My name is Pranamya, and I will be playing the witness, Andy Parr.
Okay.
Good evening, Your Honor. My name is Aneesh Sachdeva, and today I will be Dr. Alex Zuzak.
Oh, are you related to the plaintiff attorney?
Indeed, I am.
Oh, okay. I didn't know if that a coincidence or not. Okay. All right. Is there any other people you want to introduce us to on the plaintiffs before we turn over to the defense?
No, Your Honor.
Okay. Terrific. Okay. Let's hear from the defense. Who are the attorneys for them?
Good evening, Your Honor. My name is Joey Sanchez, and I'll be conducting the opening statements in today's case. And I, alongside my co-counsel, Isabel Alfonso, who'll be conducting the closing arguments in today's case.
Good evening, Your Honor.
Good evening.
We proudly represent the defense in today's case, Elias Hornby. May our witnesses also make appearances, Your Honor?
Well, yeah, I mean, they're not appearing, they're introducing. So they're welcome to introduce themselves. Go ahead.
Yes, Your Honor.
Good evening, Your Honor. My name is Amanda Puentes, and I will be playing the role of Dr. Elias Hornby.
Okay.
Good evening, Your Honor. My name is Cindy Carr, and I will be playing the role of Riley Kwan.
All right. Good evening.
With
Okay.
that, Your Honor, the defense stands ready for pretrial motions.
Okay. So let's see if we have any preliminary matters to be dealt with on behalf of the plaintiff.
Yes, Your Honor, I have three things. First, I would like to invoke Rule 603, which calls for the constructive swearing in of all witnesses, as well as Rule 615, which calls for the constructive sequestration of all witnesses, barring party representatives.
Okay.
Finally, we'd also like to bring the court's attention to Stipulation 4.
Okay.
States that Exhibits 8 and 9 have been pre-admitted and may be used freely during opening statements or closing arguments by either party.
Got it. Okay. Anything else, Ms. Jiang?
No, with that, the plaintiff is ready to proceed to opening statements.
Okay, let's see if the defense has any preliminary items they wish to bring to our attention.
Yes, Your Honor, but before we begin, we'd like to ask that everything that was granted to the plaintiff be granted to the defense as well.
I have to think about that. No, I'm kidding. There's no problem.
First, we have a few procedural matters introduced to the courtroom.
Okay.
Firstly, would you like for us to refer to you as both the judge and the jury?
Well, no, because I'm only the judge. So certainly do not talk to me as you talk to the jury, and certainly don't talk to the jury as you would talk to the judge.
Yes, Your Honor. Your Honor, we'd also like to inform you that the bailiff for the defense will be announcing the time elapsed throughout the duration of this trial by the usage of the Zoom chat.
Okay, that sounds good.
Next, Your Honor, we'd also like to know your preferences regarding screen sharing exhibits for the court. Would you like for us to ask permission before doing so, or should we just let the record reflect?
Yeah, I like the idea of you do it and you announce it while you are doing it.
Yes, Your Honor. We'd also like to know your preferences regarding redirects and recrosses. Will they be entertaining your courtroom today?
They'll absolutely be entertained. It's not up, but however, it'll be up to the lawyers whether they wish to accept the invitation.
Yes, Your Honor. And once an objection has been sustained, should we move to strike the witness response, or should we just assume it's been stricken?
In this business, having practiced for over 30 years, the answer is you never assume. So if you want something stricken, you should ask for it to be stricken.
Yes, Your Honor. And Your Honor, the defense does have a party in today's case, that being Elias Hornby, and they will be present throughout the duration of this trial.
Okay.
Next, Your Honor, we have a few substantive matters to address. We
Okay.
want to make the court aware of pretrial order 5, which states that Elias Hornby stood trial for one count of first-degree murder in relation to the death of Arthur Henley beginning on May 18th, 2025. Elias Hornby was found not guilty and acquitted.
Okay.
And finally, Your Honor, we want to make the court aware of stipulation 10, which states that all potential exhibits have been pre-labeled and pre-numbered.
Okay.
And with that, Your Honor, the defense stands ready for opening statements.
Terrific. Thank you, Mr. Sanchez. All right, let us hear the opening statement, please, from the prosecution or the plaintiff. Go ahead.
May I proceed?
Yes, please proceed.
The breach, the blame, the behavior. It's February 16th, 2025. Now, Arthur Henley is at the hospital and he's waiting for his medical treatment. Doctors, nurses, and staff members pass by, but one of them carries the medication that will cost Arthur his life. That person's name is Elias Hornby. Hornby was Arthur's relative and the person responsible for checking, preparing, and ensuring the safety of Arthur's medication. But she failed because Arthur wasn't someone she wanted to help. He was someone she wanted to hurt. And you'll hear how the defendant let a lethal dose slip through her hands, killing Arthur Henley. That is why we, the plaintiff, are suing Elias Hornby for medical malpractice. Members of the jury, we have to prove this to you by the preponderance of the evidence. That means that after today's trial, you'll find it more likely than not that the defendant owed Arthur a duty of care, breached this duty, and this breach was the cause of his death. And to prove these to you, we'll be focusing on 3 things: the breach, the blame, and the behavior. First, the breach. The evidence will show that Elias Hornby breached her medical practices. You'll hear that Arthur was supposed to have a standard dose of lorazepam, a drug that reduces anxiety. Yet you'll hear that the drug Arthur was injected with was not lorazepam, but a substance called ketamine. You'll hear how he was given 12 times the typical dose, enough to cause a coma and eventually death. But you'll hear how all of this was avoidable. Forensic toxicologist Alex Zusak will tell you no careful doctor would inject a patient without double-checking its content beforehand. What did Hornby do? We'll hear how she mindlessly proceeded with the injection. Second, the blame. The defense will claim that the person who handled the medications was an inexperienced intern, not Hornby. But that's the thing. Why would the defendant let an inexperienced intern handle such an important task? The forensic toxicologist will tell you it would be entirely inappropriate for any doctor to let an intern fill their syringe, let alone doing so without double-checking its content. Members of the jury, you'll hear how all of the blame and responsibility fell in the hands of Elias Hornby, and she failed to meet every single one of them. And finally, the behavior. Let's begin with Arthur Henley. You'll hear from Arthur's best friend, and she'll tell you Arthur seemed perfectly normal just hours before the incident. No signs of illness or fatigue. Yet you'll hear how just minutes after Hornby's injection, Arthur collapsed in the parking lot. But Arthur's behavior isn't the only one that matters here. You'll hear about Hornby's. The woman was drowning in medical school debt, and Arthur was the one helping her afloat. But you'll hear how Arthur held this debt over Hornby's head, sparking bitterness and resentment. And then, members of the jury, you'll hear about a sticky note written by the defendant while Arthur was at the hospital. The note read, and I quote, "Get the meds prepared. It's all to plan." And you'll hear how she passed this note to her intern, the same intern who had supposedly mishandled Arthur's medication. And that's why, members of the jury, at the end of today's trial, my co-counsel, Ishaan Sachdeva, will ask that you find her liable for her actions. Because when a doctor betrays her duty, this case boils down to three things: the breach, the blame, and the behavior. Thank you.
Thank you, Ms. Jiang. Okay, let us now hear from the defense.
Yes, Your Honor. Joey Sanchez for the defense. May I proceed?
Let us now hear from the defense.
May it please the court, Your Honor, opposing counsel, members of the jury. She never failed her patients. The system did. Now, Ms. Jiang just got up here and she told you a story. But sometimes when you're trying to build that story, it's easy to see what you want to see. What if I were to tell you that since the autoclave machine used to clean syringes was broken, the hospital had to manually clean every single syringe? What if I were to tell you that the hospital was understaffed and relying heavily on interns on the day of the incident? What if I were to tell you that due to the hospital's broken system, they left the risk for residue of other chemicals? In fact, what if I were to tell you that it was that risk, not Dr. Hornby's choices, that led to Arthur Henley's death? Now, would that change things for you? She never failed her patients. The system did. And because the plaintiff brought these claims, they carry the burden. They carry the burden to prove to you today, by a preponderance of the evidence, that Dr. Hornby breached the standard of medical care, that this breach was the proximate cause of Mr. Henley's death, and that this death resulted from a wrongful act of my client. And if they fail to prove even one of these elements to you today, the law requires you to find my client not liable. And they will fail because today they will not be able to prove a breach. They will not be able to prove proximate cause, and without either, there is no medical malpractice and therefore no wrongful death. What you will see today is a poorly equipped and staffed hospital, but not a reckless doctor. And to prove these facts to you today, we will call two witnesses to the stand, because this case turns on two simple truths. First, Dr. Elias Hornby did not fail her patients. She will explain that Mr. Henley personally requested her care, that she had safely treated him with lorazepam 8 times without a single complication, and that she followed standard medical procedures with no notice of any equipment failures. Second, the system failed the patients. You would then hear from Riley Kwon, the hospital's administrative coordinator, who will testify that the autoclave, the machine used to clean and sterilize medical syringes, was not working, forcing staff to manually clean syringes, creating the risk of chemical residue being left behind. Now, members of the jury, nobody in this courtroom today will tell you that this was anything short of a tragedy. It was. And we know it's easy to look at this tragedy and want to instantly label the doctor who administered that treatment responsible. But members of the jury, we ask that you look further than just who administered that treatment, but rather the actions and events that led up to this death. And when you do that, you'll see that it was not Dr. Hornby who had failed her patients, but rather it was the system. Which is why we ask that at the end of today's trial, you return a verdict of not liable. Thank you.
Okay, thank you, Mr. Sanchez. All right, before the first witness, I'd ask everyone switch to the gallery view. The button is in the upper right of your screen. This allows you to see the attorneys and witnesses at the same time. And once that is done, let us have the plaintiff call your first witness.
Your Honor, may I proceed?
Well, yeah, that's what I meant when I said call your first witness.
Of course. Good evening. Please introduce yourself to the members of the jury.
Well, time out. I was going to say I'm not seeing a witness. Oh, there we are. Okay. Why don't you start again there, Ms. Jiang? Go ahead.
Good evening. Please introduce yourself to the members of the jury.
Hi, my name is Andy Parr.
What do you do for a living?
I'm a veterinarian. I've always loved animals, and I became a vet after shadowing a veterinarian named Dr. Irtine. The moment I set foot in that clinic, I knew I had to go to vet school.
Well, ma'am, do you know your involvement in today's case?
Yes, I was a very close friend with the victim in today's case, Arthur Henley.
How did you come to know Henley?
Oh, Arthur and I go way back. We've been best friends ever since first grade, and we were pretty much inseparable. We were even voted most likely to stay friends forever in middle school. And he's actually the one who introduced me to Dr. Irtine.
Miss Parr, I'd like to turn your attention to February 16th, 2025, the day of the incident. Now, where were you at the time?
Well, I was actually at the hospital with Arthur at his request. He needed to get some sort of treatment, so of course I said yes. I would never leave my best friend alone.
Now, what was Henley like before he was at the hospital?
Oh, that morning we went out for brunch together, just the two of us. He was acting no differently than usual.
And what happened while you were at the hospital?
We arrived at the hospital at around 2:30 p.m. Once we arrived, we were almost immediately sent to a room towards the back of the hospital. It wasn't long before Arthur's doctor, Elias Hornby, came in.
How do you know Elias Hornby?
Well, Elias is Arthur's relative, and I remember Arthur mentioning her in the past. I don't know her personally, but I was never quite fond of her.
Ma'am, what happened after Hornby came in?
Hornby was explaining how she'd found a medicine that would do the trick. Then I saw them write something on a sticky note before passing it to an intern.
Would you recognize an image of the sticky note if I showed it to you?
Yes.
Your Honor, stating for the record, my co-counsel will now be screen sharing what's been pre-admitted as Exhibit 8. Miss Parr, could you please read what's written on the sticky note?
Yes, it says, get the meds prepared. It's all to plan.
Objection, Your Honor.
What is the basis for the objection?
Under Rule 403, confusing the issues. May I be heard?
Sure.
Yes, Your Honor. Pursuant to Rule 403, relevant evidence may be excluded if its probative value is substantially outweighed by its confusing the issues for the members of the jury. If I may proffer, Your Honor?
I'm listening.
We believe that opposing counsel is using the contents of this note to show a motive in Dr. Hornby. Your Honor, we are here for a civil case for medical malpractice, not a criminal case. To show motive would simply be confusing the issues for the members of the jury, as we are not here to prove a motive in Dr. Hornby. On the contrary, the plaintiff is trying to prove negligence. So this would be confusing the issues for the members of the jury and is inadmissible in today's case, Your Honor.
Okay, let me hear from Ms. Jiang.
Your Honor, I'd love to respond to opposing counsel's argument, but first of all, I'd like to bring the court's attention back to Stipulation 4, which states that Exhibits 8 and 9 are pre-admitted but still subject to objection on the grounds of relevance, foundation, or witness familiarity. 403 does not cover these.
Response, Your Honor?
I'd like to hear what you have to say about that, Ms. Alfonso.
Yes, Your Honor. While we understand that there is certain basis for the objection, 403 is a relevance objection.
Yeah, well, hold it. Okay, say no more. Ms. Jiang, I'll make it a little bit easier for you. I am finding that Rule 403 is a valid objection for this exhibit. So you to please respond to that objection.
Yes, Your Honor. Well, as opposing counsel said, we're trying to use this for Elias Hornby's motive. His motive to potentially kill Arthur Henley, which is the deceased in this case. This is certainly relevant because it shows Elias Hornby had the motive to kill Arthur Henley, not just medical malpractice, but murder.
Final response, Your Honor?
Sure.
Your Honor, as I mentioned previously, this goes directly to our objection to 403 confusing the issues. We are here on a civil case, not a murder case. As mentioned in the pretrial, Your Honor, Elias Hornby was found not guilty of first-degree murder. Therefore, this is going to confuse the members of the jury and confuse the issues of today's case, and it's inadmissible.
Yeah, Ms. Jiang, before you mentioned the word murder, I was thinking about your side, but then you demonstrated and kind of made Ms. Alfonso's argument for her. So the objection is sustained.
Motion to strike offending testimony, Your Honor?
The testimony is stricken and the jury will disregard it. Continue, Ms. Jiang.
Yes, Your Honor. So, Miss Parr, what happened after this exchange?
While I was waiting with Arthur, I saw the same intern that Elias had passed the note to an unusual amount of times. She'd walked by at least 5 times to check on Arthur, and apparently her name was Finley Riveras. Poor thing, she was stuttering and stumbling, and while I try to give people grace, it still made me nervous with Arthur's life on the line.
What else did you observe?
Well, 2 minutes later, an intern came in and confirmed that Riveras was new and out preparing the medicine. While we waited for her to return, I heard some concerning things from the doctors and nurses.
Why were they concerning?
Oh, well, I kept hearing this jumble of instructions directed at the intern, like, don't get the wrong tube, don't mix up.
Objection, Your Honor.
What is the basis for the objection, Ms. Alfonso?
Pursuant to Rule 801 hearsay, may I be heard?
No, because you've already said it's hearsay, so there's nothing more to hear. I want to hear what Ms. Jiang has to say in response to that, and then you can respond to what Ms. Jiang says. Go ahead, Ms. Jiang. I heard hearsay.
Your Honor, hearsay is an out-of-court statement made for the truth of the matter asserted. In this case, these statements are not assertions, rather they're commands, and commands have no truth matter because they aren't claiming anything to be true or false. They're simply telling someone to do something. These statements, get the meds, don't mix up the meds, don't get the wrong tube, they're commands. Therefore, this statement cannot and is not being offered for any truth matter.
I gotta confess, I never heard that in my time. You're saying to me that a command cannot be hearsay because it's a command?
Command, although the statement being said is an out-of-court statement, it's not being offered for the truth of the matter asserted, because when you have a command, there is no truth matter. It's a black and white, do this. There's no truth value behind it.
Okay. Ms. Alfonso, what do you have to say about all that?
Yes, Your Honor. Under Rule 801A, there needs to be an assertion to these statements, and we, the defense, contend that there is an assertion to these statements. These statements, we believe, were not made as commands, but rather in a sarcastic way or in a joking manner to this intern who had previously messed up these medications, Your Honor. And there is an assertion behind this. The assertion being, the truth value being that you have done this before, do not do it again. Therefore, we don't believe this falls under a command, and it has an assertion behind it.
Yeah, no, the objection, no, the objection is sustained. I guess to put it a different way, Ms. Jiang, assuming that I follow your argument, there's been nothing demonstrating anything other than your testimony, and you're not allowed to testify, that anything is a command. As far as I'm concerned, it was an out-of-court statement, and it appears to be offered for the truth of the matter asserted, so therefore it is hearsay. So the objection sustained. And why don't you please proceed?
Motion to strike the offending testimony, Your Honor.
The testimony is stricken and the jury will disregard it. Continue, Ms. Jiang.
Miss Parr, what was Finley's reaction?
I heard her respond by saying, I didn't. I promised that only happened last time, not again.
Objection, Your Honor.
What is the basis for the objection, Ms. Alfonso?
801 hearsay again, Your Honor.
Okay, one more time from the witness. What was it? What were you saying, Ms. Parr?
I said, Finley Rivera said that I didn't. I promised that only happened last time, not again.
Got it. Okay, Ms. Jiang, tell us why that is not hearsay.
Your Honor, we are not using this statement for the truth of the matter. Instead, we are using it to show Andy's subsequent action, which, Your Honor, if I may proffer.
Okay, go ahead.
We're using it to show how Rivera's words about making a past mistake concerned my witness and prompted her to voice those concerns to Elias Hornby. And Your Honor, we'd be fine with setting a limiting instruction to the jury that they should not consider this statement for its truth and only for Ms. Parr's subsequent action.
Okay, let me hear what Ms. Alfonso has to say about all that.
Your Honor, we still believe that these statements are being for the truth value. And if I may, Your Honor, I would also like to then raise a 404 objection.
Okay, go ahead. What's the 404 objection?
Your Honor, under Rule 404, it's improper character evidence. Evidence of a character trait may not be used to prove that someone would act on that character trait again. And in this case, Your Honor, the plaintiff is going to use these statements as proof of Ms. Rivera's irresponsibility and mixing up these medications. Therefore, it's improper character evidence and it's hearsay, as we believe that they plan on using the truth value behind these assertions. Even if it's for the effect on the listener, they're still arguing the truth value.
Response, Your Honor?
I'm listening, Ms. Jiang. Go ahead.
Opposing counsel is saying that we're using these statements about Finley Rivera's making a mistake in the past to prove that she's more likely to make a mistake now. But Your Honor, we're not using all of these statements for the truth of the matter. Your Honor, this statement about the intern's past mistake may go to the defense's case theory, but not the plaintiff's. What matters for us is how this witness's subsequent action of voicing her concerns shows that Dr. Hornby was aware of a potential problem. We're trying to show how Hornby breached his medical practices.
But I guess so you're saying, Ms. Jiang, you are not trying to prove that her actions were in conformity with her past practice.
That's correct. We're only using this to show how it affected this witness's subsequent action.
Okay. I'm going to overrule the objections this time and we'll allow this. Go ahead, Ms. Jiang.
All right, let me re-ask my question, Ms. Parr. What was her reaction?
I heard her respond by saying, I didn't. I promised that only happened last time, not again. At the time, I was concerned. What does that even mean when my best friend is sitting right there about to get injected?
Did you ever voice those concerns?
Absolutely. When Dr. Hornby came back, I told her I was worried about Rivera's potentially mixing up the meds. But Hornby assured me that she'd triple-checked the medication and said that Arthur was getting exactly what he needed to get, whatever that meant. And then she proceeded with the injection.
What happened after he got the injection?
As we walked towards our car, Arthur began to walk slower, and he stopped answering me with words, just head nods. I even tried cheering him up by mentioning that time he got chased by a raccoon, but he didn't respond, so I turned around and I found him on the ground.
Miss Parr, what happened after he collapsed?
He was taken into the ER with a stretcher and everything and sent into a private room. The hours that followed were intense. To sit outside knowing that my best friend's life was on the line, it was just a lot to handle. When I heard that Arthur had passed, I just couldn't process it.
Thank you for sharing, Miss Parr. At this time, I have no further questions, Your Honor.
Okay, thank you, Ms. Jiang. Cross-examination, Ms. Alfonso.
Yes, Your Honor. Isabel Alfonso for the defense. May I inquire?
Yes, that's what cross-examination is. Go ahead.
Good evening, Ms. Parr. I'm going to be asking you a series of questions that generally call for a yes or no response. If you cannot answer, please let me know, okay?
Thank you.
Ms. Parr, a moment ago, you testified about what you personally know about Arthur Henley's death.
Yes, I did.
And you personally blame Dr. Hornby for that death.
Yes, I do.
Well, I want to talk about why you might be saying that. Because you would say that you and Mr. Henley were best friends, right?
Yes, we were ever since first grade, so yes, we were pretty good friends.
You had known him since you were 5 years old.
Yes, I have.
You considered him to be family.
I did.
But Miss Parr, you'd agree with me in saying that you also have a lot of gratitude towards Mr. Henley.
Yes, I do. After all, Arthur's the one who got me into vet school, so yes, I have a lot of gratitude.
Exactly. Let's talk about why that is, because 30 years ago, you found your job.
Yes, I did.
Without Arthur Henley, you don't know if you would have that job today.
That's true. He's the one who introduced me to Dr. Irritine, so that's correct.
Exactly. 30 years ago, you found your passion as a vet.
Yes, I did.
And without Arthur Henley, you don't know if you would have found that passion either.
That's true.
And because of all of that, his passing was a great loss for you.
Yes, it was. I don't know what to do without him anymore, so yes, it's very hard.
It was such a big loss that you have decided to sue Dr. Hornby.
Yes, I have.
You want to ensure that your best friend, Arthur Henley, gets justice.
Yes, that's true.
Because you would say that nobody can kill your best friend and get away with it.
Yes, because like you said, I want to make sure that justice is served for Arthur. So yes, that's true.
Okay, Miss Parr, now that we have your relationship with Mr. Henley out in the open, I want to talk a bit more about why you chose to sue Dr. Hornby today.
Okay.
In saying that you never liked Dr. Hornby.
No, I didn't.
You never liked her because you felt like she was cold.
Yes, I just thought that Arthur deserved better people in their corner. So yes, I did think they were cold.
There was just something about her demeanor that just wouldn't sit right with you.
Yes.
And now you blame the death of your best friend on her.
Yes, like I said, they're...
Objection, Your Honor, as to argumentative.
Hey, what do you say about that, Miss Alfonso?
Your Honor, we are not asking the witness to come to any conclusions based on the fact of this case, and under the objection of argumentative, for a question to be argumentative, I would have to ask the witness to come to a conclusion about the facts of today's case. But this is based off of the witness's personal perception and opinion.
Yeah, Miss Jiang, I'm not sure I followed. I'll give you one last crack at why you think this is argumentative.
Your Honor, Miss Alfonso is saying that my witness blames Elias Hornby for what happens. That's clearly argumentative.
No, I don't agree. I think the objection's overruled. Go ahead.
Ms. Parr, would you like me to re-ask my question?
Yes, please.
Ms. Parr, you now blame the death of your best friend on Dr. Hornby, correct?
Yes, I do.
Well, if you blame that death on Dr. Hornby, I want to talk about what you personally know about it.
Okay.
You accompanied Mr. Henley to his treatment on February 16th, 2025.
Yes, I did. He asked me to join him for treatment, so yes, I did accompany him.
And he specifically requested Dr. Hornby to administer his treatment.
Yes, he did. He wanted family to be treating him, so yes, he did.
And you'd agree with me in saying that you trusted Mr. Henley.
Yes, I did. He was my best friend, so of course I did.
And Mr. Henley trusted Dr. Hornby with his care.
Yes, he did. After all, you can only really trust family, can't you? So yes, he did.
Exactly. You did not question Mr. Henley's choice to receive care from a family member,
No, I didn't.
even though that family member was Dr. Hornby.
Yes.
And when Dr. Hornby came back with the injection, you brought up your concerns about Rivera's.
Yes, I did. I told Dr. Hornby that I was scared that Riveris would mix up the medicine, but Dr. Hornby reassured me. So yes, I did talk to her.
Exactly, Miss Parr. Dr. Hornby assured you that she triple checked the medication
Yes, that's what I said.
and that Mr. Henley was getting exactly what he needs to get.
Yes.
Well, now let's move on and talk about your knowledge and about what you don't know. Because you don't know what medication Arthur Henley was supposed to receive.
No, I don't.
You don't know how the hospital operates behind the scenes.
No, I do not. As a veterinarian and not a hospital worker, I didn't know how the hospital works. So no, I don't know about it.
Exactly, Miss Parr. So you wouldn't be able to know if there were issues with the hospital system.
That's true.
All you know for certain is that your best friend is gone.
Yes.
And you believe Dr. Hornby is to blame.
Yes, I do.
Objection, Your Honor, as to asked and answered.
Okay, what do you say about that, Ms. Alfonso?
Yes, Your Honor. We are simply using this line of questioning for clarification for the members of the jury as we are wrapping up this cross-examination.
All right, since it's being wrapped up and I don't see it as a big deal, we'll overrule the objection this time, but let's move it along, Ms. Alfonso.
Yes, Your Honor. Ms. Parr, would you like me to re-ask my question?
Yes, please.
You believe Dr. Hornby is to blame for the death of your friend,
Yes, I do.
the same Dr. Hornby you've never liked.
Yes, because I want justice to be served for Arthur. So yes, I do.
Okay, ma'am. Thank you. No further questions at this time, Your Honor.
Okay, thank you, Ms. Alfonso. Ms. Jiang, any redirect examination?
No, Your Honor. May this
Okay.
witness please be excused?
With that, Ms. Parr, you're excused. Thank you very much. Does the plaintiff have any other witnesses?
The plaintiff would like to call Dr. Alex Zuzak to the stand.
Okay. Please proceed.
Good evening. Can you please introduce yourself to the court?
Of course. My name is Dr. Alex Zuzak.
Dr. Zuzak, what do you do for a living?
I work at the Langford Hospital of Tilly, and I am the director of clinical and forensic pharmacology.
What kind of work do you do in that role?
In that role, I analyze overdose deaths, drug mislabeling incidents, and failures in hospital drug protocols. I have 15 years of experience in this field.
What qualifies you for this kind of work?
I have expertise in two types of fields. I got my bachelor's degree in chemistry from Tilly State University and a master's degree and doctorate in forensic toxicology from Willow School.
Dr. Zuzak, do you have any further qualifications before you went to work?
Yes, before work, I spent a few years at the Little Hamlet Drug Evaluation School, where I focused on drug delivery systems in hospital settings. I also published some research on the effects of misused anesthetics, and it was well perceived in the scientific community.
Have you ever testified in court before?
Yes, I have testified in both civil and criminal cases on numerous occasions.
What is your involvement in today's case?
In today's case, I was hired by the plaintiff counsel to determine what drug was injected into Mr. Arthur Henley by the defendant, Dr. Elias Hornby, and whether there was any medical mishandling.
Did you have sufficient facts and materials to review?
Yes, I did. I was able to review the affidavits of the witnesses, the exhibits related to this case, medical materials such as the patient histories, and a sample of the syringe. These materials were sufficient enough to form a conclusion in this case.
Did you use any methods to accomplish this?
Yes, I used the ACE method, which is a little acronym that stands for analyze, compare, and evaluate. It's regarded as the golden standard in the medical field.
And did you properly apply these methods?
Yes, I made sure it was both accurate and reliable.
Dr. Zuzak, let's start with your investigation. What was the situation you were brought in to investigate?
On February 16, 2025, Arthur Henley was admitted to Langford Hospital at 2:34 p.m. with some symptoms of arrhythmia complications, acute anxiety, and mild hypertension. The acting medical professional, which was the defendant, Elias Hornby, administered Henley at 2:49 p.m. with what Mr. Henley believed to be a standard dose of 10 milligrams of lorazepam.
What is lorazepam?
Lorazepam is a common drug used to reduce anxiety and was successfully used to treat Mr. Henley in the past. However, in my review of the materials, Mr. Arthur collapsed 5 minutes later after taking this particular injection. This led me to the conclusion that the administered drug was something entirely different. In my experience, lorazepam does not induce this type of response.
What did you do in response to your conclusion?
I requested the syringe that was used for Mr. Henley's injection to be tested. It was stored and sealed well after his death.
Did you run any tests to identify the contents of the syringe?
Yes, I ran a high-performance liquid chromatography, or HPLC, to test it. This is the A in ACE, which is analyze. It's widely used and accepted to analyze chemicals, and so what it does is it basically separates and identifies the compounds in different drug samples. Here's what it looks like. I've prepared a demonstrative to share with the court today. Now, I know this looks complicated, but let's take it one at a time.
How do you run this test?
The way an HPLC test works is that the suspected drug sample, which is lorazepam, is mixed with a solvent to get it into the mobile phase so we can put it into the machine for further analysis. That's the first step. The second step is when the sample is run through a special tube that has special particles in the machine. Now, imagine pouring different liquids into the column, and some might go faster, some might go slower, and some might just stay the same. The HPLC machine does the same thing. Depending on how fast the sample reacts to the particles, liquids are sorted into different detectors that can be used to identify the chemical properties.
Are there any more elements of this test?
Yes, the form of detector used to identify the chemicals, which is the third step. In this case, I used the UV light detector. Depending on how much UV light is absorbed, we can identify the content in the syringe.
What were the results?
This is the C in ACE, which is compare. Despite Dr. Hornby's claims, there was no trace of lorazepam. Instead, the chemical in the syringe absorbs exactly 210 nanometers, the same amount as ketamine.
What is ketamine?
Ketamine is the type of anesthetic that can create pain relief and is approved for medical practice. It takes around 30 to 60 milligrams in 5 to 10 minutes to be effective. I wanted to use the mass spectrometry test, which is generally considered more accurate, but I was held in a limited manner, and I didn't have the required equipment anyway.
Did the lack of mass spectrometry impact your analysis?
Not really. I mean, although the mass spectrometry tests can analyze more.
Objection, Your Honor. Pursuant to Rule 611C, I believe this is a leading question, as opposing counsel just asked, and has led the witness to a specific answer. Therefore, we move to strike this testimony.
Let me understand, Mr. Sanchez. What specifically did you have a problem with?
The question, as it was leading the witness to a specific answer.
All right, let me hear the question again, Attorney Sachdeva.
Did the lack of mass spectrometry impact your analysis?
Yeah, I mean, that is a leading question. I mean, so yeah, there's really no other way around that other than to rephrase the question. So the objection is sustained.
Your Honor, we move to strike that testimony.
Yeah, that testimony is stricken. If Mr. Sachdeva, if you want to re-ask that question in a less leading fashion, we'll go from there.
Yes, Your Honor. Dr. Zuzak, did anything else impact your analysis?
No, although mass spectrometry tests can analyze more complex compounds, UV detectors are just as good for general tests and confirm the presence of ketamine in the syringe. This also matched what we found in Mr. Henley's toxicology report, which showed the ketamine presence was 10 to 12 times the
Objection,
amount.
Your Honor. Pursuant to Rule 801 hearsay, may I be heard?
Yeah, what's the hearsay? I'm lost. Go ahead.
Your Honor, the witness just referenced out of court document by saying the dose was 10 to 20 times, as that comes from the autopsy report. And I believe opposing counsel has to lay the foundation from where they got this information from.
Well, what is the objection, Mr. Sanchez? Is the objection a lack of foundation, or is the objection hearsay?
We amend the objection to lack of foundation.
Okay. All right. Mr. Sachdeva, I'm listening. What is your response to that?
Your Honor, I do believe I laid the accurate foundation, as it is on the record that ketamine was found in Dr. Henley's toxicology report, and Dr. Zuzak is just clarifying how much was found.
Your Honor, if I may?
Sure.
The specific statement 10 to 20 times the dose comes from the autopsy report. The witness does not have a specific knowledge that it was 10 to 20 the dose, as it comes from this out-of-court exhibit. Therefore, we ask that opposing counsel show the exhibit to the court.
All right. Let's hear what Mr. Sachdeva has to say about that.
Your Honor, earlier in Dr. Zuzak's testimony, I asked the question, did you have sufficient facts and materials? And in that, Dr. Zuzak testified to reviewing all the affidavits, all the exhibits, all the medical materials, and a sample of the syringe. So again, I do believe I laid the foundation.
Your Honor, if I may?
No. Mr. Sachdeva, you have to listen to what the question was. He said, well, he would have no objection if you showed the autopsy report as a document. I'm not sure I'm understanding. I'm not understanding any of these things. Okay, so let's back up. Mrs. Sachdeva, the objection is hearsay now, okay, because it sounds as if Mr. Sanchez, and actually, you still have not laid, I have not seen a sufficient foundation, so I don't even have to get to the hearsay. The objections are sustained, okay, on both hearsay and lack of foundation. So you're welcome to try and fix that, okay, and that's up to you. But the objections, as argued by Mr. Sanchez, are sustained on both grounds.
Yes, Your Honor.
Let's get to the final step of your method. Evaluate, Dr. Zuzak. All in all, doctor, what is your final conclusion?
I can conclude with a reasonable degree of scientific certainty that Mr. Arthur Henley was injected with ketamine and not lorazepam by Dr. Elias Hornby.
Thank you. No further questions.
Okay, Mr. Sanchez, cross-examination.
Yes, Your Honor, but permission to adjust my camera?
Sure. Okay, I was going to say at the end of this adjustment, I hope it works. All right, go ahead.
Joey Sanchez for the defense, Your Honor. May I inquire?
Yes, that's typically what means it says cross-examination. Go ahead.
Now, Dr. Zuzik, a moment ago, you told the members of the jury about your conclusion in today's case.
Yes.
And you would say that you are being paid for that testimony, correct?
Yes, I am.
Well, I want to talk exactly about what you are being paid, because you've been paid $75,000 for your consulting and report, yes?
Yes, my time is very valuable.
And you're paid an additional $5,000 for every hour you testify in court.
Yes, I am.
So the more time you spend testifying, the more money you make, correct?
Yes.
That means that this case is financially beneficial to you, isn't it?
Beneficial or not, the financials is just an additive bonus. I am here to present my analysis in this case today.
So is that a yes to my question?
Yes.
Moving on, let's talk about how you investigated this incident, because you were not at the hospital on February 16th, 2025, correct?
Yes.
So everything you know comes from after the fact testing, right?
Yes, and all the witness statements, all the exhibits, and all the information that I did review.
And you requested access to the syringe, yes?
Yes.
And to identify the chemical properties of the syringe, you used an ultraviolet detector, is that right?
I did.
Yet, a mass spectrometry test, otherwise known as MS testing, is generally considered more accurate than UV testing, is it not?
It is.
As MS testing can detect compounds at much lower concentrations, yes?
Yes.
It can provide detailed molecular information.
Yes, it can.
And it's considered more reliable for complex or contaminated samples, correct?
Yes.
But you did not use MS testing in this case, did you?
No, as I mentioned in direct examination, I was limited in a retained manner, and on top of that, the UV light detector is not less reliable. It does the same job.
Yet you just stated a few moments ago that the MS testing is considered more accurate than UV testing.
It is, but I will find the same conclusion with both.
But you did not have the resources to use MS testing because the plaintiff did not pay you enough. Is that right?
No.
So are you saying that you didn't use the MS testing because the plaintiff did not pay you enough?
No, the plaintiff did pay me, but for the mass spectrometry test, it was not necessarily needed as we had the UV light detector test, which did the same job.
Exactly, but you were planning on using the MS testing until the plaintiff decided to pay you less.
Yes, it wasn't much of a difference.
But that is a yes to my question.
Yes.
Now, with that in mind, I want to move on and talk about your conclusion in today's case. Because you believe that Dr. Hornby caused Mr. Henley's death.
Yes.
And you reviewed testimony as part of your investigation, correct?
That's true.
So you were aware that the autoclave had been malfunctioning for weeks.
Yes.
Which meant that the hospital had to manually clean every single syringe. And if not done perfectly, residue of chemicals could remain. Is that right?
It is, but at the end of the day, it is the doctor's responsibility to double check the contents of the syringe.
Yeah, in this case, possibly ketamine could have remained. Is that right?
Yes.
But just to make this clear for the jury, you did not incorporate that malfunction into your analysis today, did you?
You see, the thing is that I found 10 to 12 times the amount of ketamine, not just tiny bits of residue.
But you did not incorporate the malfunction of the autoclave not working into your conclusion in today's case. Is that right?
I did. I used the 10 to 12 times of the ketamine found, and that did not seem like it was bits of residue.
Thank you, but let me redirect you to what I actually asked. Nowhere in your conclusion does it mention the autoclave being broken. Is that right?
Yes.
Thank you, Your Honor. No further questions.
Okay, Mr. Sachdeva, any redirect examination?
No, Your Honor.
All right, with that, Dr. Zuzak, you are excused. Thank you very much.
Thank you, Your
Does
Honor.
the plaintiff have any other witnesses?
No, Your Honor.
Okay. Do you folks customarily take a break in between the plaintiff's case and the defense case? Is anybody hearing me?
Yes, Your Honor. If Your Honor would like, the defense is amenable to a 5-minute recess.
Well, I wouldn't like anything. I'm just asking what you folks would like. If you guys agree on 5 minutes, I'm fine with that.
5 minutes sounds perfect.
Terrific. It is now 55 minutes after the hour. That means we will start on the hour even with the defense case. Okay? So everyone take a 5-minute break. Okay. Is the defense ready to present their case?
Yes, Your Honor. The defense would now like to call their first witness, Dr. Hornby, to the stand.
Okay, please proceed.
Good evening, Dr. Hornby. Could you please introduce yourself to the court?
Good evening. My name is Dr. Elias Hornby, and I am an attending physician at Langford Hospital in Tilly.
Could you tell us about your medical background?
Of course, I earned my bachelor's in molecular biology from the University of Tilly in 2002, my medical degree from the Tilly School of Medicine in 2006, and completed residency and fellowship at Little Hamlet General Clinic with additional training in pharmacological risk management for elderly patients.
And how long have you been a licensed physician?
Honestly, it's been a while. I'd say like 13 years. I started in 2017.
Well, Dr. Hornby, I'd like to talk to you about why we're here today. Who was Arthur Henley?
He was my paternal uncle.
How would you describe your relationship with your uncle?
Honestly, it was strained. He paid for some of my medical schooling, but had always reminded me of it and was inconsistent about payments. I mean, overall, he was still family.
And Dr. Hornby, do you know why you're here today?
Yes, I am being sued for medical malpractice and the wrongful death of my uncle after I had treated him.
But Dr. Hornby, had you ever treated your uncle before the incident that caused his death?
Yes, of course. I had treated him with lorazepam at least 8 times without any issues in the past.
Well, let's talk a bit more about what happened on February 16th, 2025. How did your uncle end up under your care that day?
He was admitted with arrhythmia complications, anxiety, and mild hypertension. He specifically requested that I be the one to consult him.
So what did you do, Dr. Hornby?
I followed the standard procedure. I reviewed his medications, and lorazepam was appropriate and had worked in the past. I instructed my intern, Finley Riveras, to prepare a syringe of lorazepam, and I administered the medication into Henley's right arm around 2:47 p.m.
And how did Henley appear after you distributed the medication?
He seemed stable. I observed him briefly. I kept him in the office for a couple more minutes, and he showed no negative reaction. So I had discharged him at 2:54 p.m.
Dr. Hornby, after you discharged your uncle, what happened?
Oh, God. He collapsed. He was brought back on a stretcher with severe vital instability.
When he was brought back into your care, what did you do?
They brought him back and I hooked him up to a vitals machine. He was showing high heart rate, high blood pressure, bicardia, and dangerously low oxygen levels. I called in another doctor, Dr. Conroy Fischler, to assist me, but Arthur, he flatlined. I immediately began emergency protocol and chest compressions for about 4 minutes after.
Were your attempts to resuscitate him successful?
Unfortunately, not. Conroy arrived and we attempted to use a defibrillator, but to no avail, and Henley was declared dead at 3:17 p.m.
Dr. Hornby, do you need a moment?
No, it's okay, thank you.
Dr. Hornby, has something like this ever happened before?
I've only witnessed one death, and it was while I was still in residency and shadowing. It had been so long since I've had a patient pass away under my care. Henley's felt like the first all over again.
After the accident, did you retrace to understand what caused this?
I had to. I checked the lorazepam vial used, confirmed the label was correct, and I later learned that the syringe contains ketamine residue. I began trying to determine where the issue came from.
Well, what do you believe went wrong, Dr. Hornby?
I don't know. It could have been the pharmacy, the supply chain, Finley, or hospital administration. I believe it to be a failure somewhere in the line of production.
Line of production, what does that mean?
There has been a malfunctioning autoclave on the ward for weeks, and the team had been relying on chemical rinses. I wasn't made aware that that was still in effect.
So what does that mean for the syringe used on Henley?
Well, I told my intern Finley to take one from the drying rack, so it would have been freshly washed. I don't know if they took the wrong syringe, filled it with ketamine on accident, or had just not been cleaned in accordance to hospital standards.
Dr. Hornby, you mentioned your intern, Finley Riveras. I'd like to talk to you a bit about them. Could you describe some situations that raised concerns with Riveras?
I have a couple interns working under me, and Finley was one of them. And let's just say Finley had a lot to learn. One time they filled the syringe with the wrong substance entirely, and I was so upset, I almost fired them on the spot.
And did something happen the day your uncle was under your care?
Yes, it was right after Henley was discharged.
What did Finley say that concerned you?
Well, right after we discharged Henley, Finley complained that my colleagues were still lecturing him about the accident I mentioned earlier, telling me that it was just a mistake and that you don't have to check every drop of a substance. I was appalled.
And did you ever bring these issues to your supervisors?
Of course. I had told my supervisor, Dr. Sawyer, about both incidents.
And was anything done?
The first time, no. Dr. Sawyer convinced me to give Finley another shot. Something about knowing the parents from residency. Ridiculous, if you ask me.
What about the second time?
Well, I reported it immediately and asked for Finley's removal. From what I know, their internship at Langford has been terminated.
Well, Dr. Hornby, what do you believe to have happened?
I think there was some issue with the autoclave or an unclean syringe, a system error that failed my uncle.
Could you have any way of knowing that these errors would have caused failures during treatment?
No, none of these were known to me or visible to me at the time. And I strive to do my best as a physician regardless of who I'm treating.
Thank you, Dr. Hornby. No further questions at this time, Your Honor.
Okay, thank you, Mr. Where'd he go? There we go. Mrs. Sachdeva, cross-exam. He vanished again. Cross-examination.
Yes, Your Honor. Good evening, ma'am. I'd like to start by discussing your relationship with Arthur Henley. He's your paternal uncle.
Yes.
You've always had a somewhat strange relationship?
Strange? I would say we had a normal relationship. I wouldn't say it's strange.
Let's discuss on why that might have been. You remember speaking with your uncle 9 years ago?
Yes.
This was at your uncle's mansion?
Yes, if I remember correctly.
There was a koi pond there, correct?
A koi pond?
Yes.
Uh, yes.
An expensive koi pond?
I couldn't tell you how much it's worth, but I mean, looked like a very nice koi pond.
And your uncle told you that if you play your cards right, you could have this pond one day.
Objection, Your Honor.
What is the basis for the objection, Ms. Alfonso?
Pursuant to Rule 801 hearsay and pursuant to 401 relevance, Your Honor.
Okay. Mr. Sachdeva, which one do you want to argue about first?
Let's start with the hearsay.
Go ahead.
Your Honor, we're not using this statement for the truth of the matter asserted. We do not care whether Arthur Henley actually intended to leave this possession to the defendant. What we care is about how the statement affected to the defendant, which in this case goes to the motive. We care about the effect on the listener, potentially providing the defendant with a probable motive to commit the crime. We'd be amenable to a limiting instruction to the jury on this effect, that this statement rather not be taken for the truth, but for the effect on the listener.
Okay. No, I don't. I want to hear the relevance part too.
Your Honor, relevance is a low bar, and we believe that this evidence will go to show the defendant's motive and the state of mind, and that the koi pond was a significant expenditure, creating budget pressure that influenced how medications were sourced and administered.
The koi pond influenced how medications were sourced. All right, I want to hear about that, Ms. Alfonso.
Yes, Your Honor. If I may amend my 801 hearsay objection to then a 403 objection, confusing the issues, if I may be heard.
No, because I want to hear. You can't do that to the judge. What you're right now dealing with an answer to the relevance, right? So I heard the relevance is a low bar and so on, and something about I didn't totally get it, but I want to hear what your answer is to the relevance before you get into another objection.
Yes, Your Honor. While we understand that relevance is a low bar, there is still no correlation between a koi pond and the will of Arthur Henley with the negligence or alleged negligence of today's case and the administration of medication, Your Honor. So
Yeah,
while
I got to tell you, Mrs. Sachdeva, you lost me on that koi pond. So the objection is sustained. I don't get it at all. I don't see why how that's relevant. So maybe I'm missing it. But on the basis of relevance, it's sustained. So continue on without dealing with the pond.
motion to strike offending testimony.
Yeah, all that stuff about the koi pond is stricken. I just you didn't make the connection clear enough or quick enough, and got lost in the weeds, I think, on it. So that's why it's stricken. So go ahead.
Let's move on. Your uncle paid for your medical schooling, didn't he?
He paid some.
He never let you forget it?
No, it was a constant reminder, unfortunately.
And not only did he constantly remind you of that fact, but he threatened to withhold those payments?
He did. Ultimately, I was the one that ended up paying for the rest of my medical schooling, and I felt that it was best for me to pay it off on my own anyway.
These monthly payments stopped coming on November 27th, 2024?
Correct.
Let's discuss these in more detail. Your Honor, let the record reflect that my tech is now sharing the screen, which has been pre-marked as Exhibit 6 for identification purposes. Ma'am, what I've just displayed, these are your medical debts, correct?
This is correct, yes.
They look fair and accurate?
Yes.
The plaintiff offers evidence.
Excuse me?
Okay, so as I understand it, this is being offered into evidence by the plaintiff. Ms. Alfonso, what's your response, if any, to this? Do you have any objection?
Yes, Your Honor, on the basis of 403.
What's the basis of 403?
Confusing the issues, Your Honor, if I may explain.
Okay, go ahead.
Yes, Your Honor. These medical debts that opposing counsel is displaying, Exhibit 6, this again goes to show a motive in Dr. Hornby. This has nothing to do with medical malpractice or wrongful death. Opposing counsel would be using these documents to show a motive, and it would confuse the issues for the members of the jury, as we are not here to prove a motive in Dr. Hornby. The plaintiff is here to prove negligence. Therefore, it's inadmissible in today's case.
Okay, Mr. Sachdeva, what do you have to say about all that?
Your Honor, I do believe this document does go to motive, as opposing counsel is stating, and it goes to show the connection between Hornby and Henley, and it also goes to show how it also goes to show how Dr. Hornby could have been motivated to could have been motivated to malpractice on Dr. Henley.
Miss Alfonso, I'm not understanding your argument on this at all. Okay, meaning I don't understand why is it we don't care, okay, if Hornby had a chip on his shoulder, okay, as it relates to Henley. And if this goes to show that, why it doesn't become relevant. Meaning maybe he was just, lackadaisical in his care because he was pissed off about how he was treated financially by Henley. Why is that not relevant to us?
Your Honor, we're not arguing that this evidence is irrelevant, but relevant evidence may be excluded if its value of confusing the issues to the members of the jury is.
Your objection's overruled. I see absolutely no. I follow this. I don't understand what the basis of this objection is at all, because I think that it is relevant. And when you look at Rule 403, okay, and let's take a half a second to look at it. Okay, the probative value has to be substantially outweighed, okay, by the prejudicial effect or confusing the jury. You have not demonstrated the substantially outweighed part, and that's why the objection is overruled. Continue, Mr. Sachdeva.
You had a total of $250,000 of medical debt, correct?
That is correct.
$190,000 was paid.
Well, hold on. Maybe I missed it. Did you offer this document into evidence?
I did, Your Honor.
Okay. So because typically you wait to hear the court say, okay, it's accepted into evidence. And I didn't remember if I said that or not, at least at this trial. But it is accepted into evidence. Now continue.
Dr. Hornby, you had a total of $250,000 of medical debt, correct?
That is correct.
$190,000 was paid?
Yes.
And much of this was covered by your uncle?
Some of it was Henley, some of it was me.
I'd like to transition now, ma'am, and discuss some of the practices that occurred under your supervision at the hospital. You used to supervise an intern named Finley Riveras?
I used to, yes.
And it is your opinion that the intern process at the facility is far too lenient?
You could say that.
Let's talk about that leniency. On a past occasion, Finley Riveras filled a syringe with the wrong substance, didn't she?
Yes, this is correct. This was when I went to Dr. Sawyer the first time and asked for Finley's removal.
You almost fired her for this transgression?
I wanted to, but ultimately it wasn't up to me.
So you didn't eventually decide to keep Finley Riveras on your team?
I didn't necessarily decide. My supervisor, Dr. Sawyer, convinced me to keep Finley on.
But the decision was ultimately yours.
I couldn't exactly disobey Dr. Sawyer.
And this made you want to double check the contents of the syringe, of the contents of everything that the interns did.
Yes, this is correct.
Because at the end of the day, doctor, ultimately, the administration of treatment is your responsibility as the physician.
It is.
But to be clear, it was Finley Riveras who brought you the syringe that you administered to your uncle, correct?
Yes, I gave him written instructions for the retrieval of the syringe with lorazepam.
You injected your uncle with the syringe when Riveras returned with it?
Yes.
And ma'am, you said you would double check everything that she did?
I had said that I would be more attentive.
Yet you did not double check the syringe that was injected into your uncle.
I gave one of my interns written instructions, and I trust all my interns to be responsible enough to be able to follow written instructions.
After this injection, Finley exclaimed, "You don't have to check every single drop of substance," didn't she?
This was not exactly after. That is speaking to a prior event.
You moved to fire Finley from her position following this statement?
I moved to ask for Finley's removal yet again after I had confronted Dr. Sawyer about both incidents.
Dr. Hornby, you'll have your chance to explain on redirect, but for now, I would like you to simply answer my question with a yes or no. You moved to fire Finley from her position following this statement?
I did.
But this move to terminate came after you injected your uncle with the syringe that she provided.
Yes.
I'd like to discuss that syringe now specifically. Arthur was declared dead an hour following this injection, 3:17 p.m.
My uncle did pass away, unfortunately.
You sent that syringe in for forensic testing?
Of course, after somebody that I had held so close to me passed away under my care, I felt that it was my duty to understand what went wrong, so I could never live it down.
There were traces of ketamine on the syringe you administered to your uncle?
I had found that.
This ketamine was injected directly into your uncle's bloodstream?
This ketamine was found in traces of the syringe.
Dr. Hornby, I'd like to redirect you back to my question. This ketamine was injected directly into your uncle's bloodstream.
After I had given Henley what I believed to be lorazepam, I had then realized that there was ketamine's residue in the syringe.
Again, redirecting you back to my question. So that ketamine was injected directly into your uncle's bloodstream.
That could have happened.
I would like a yes or no answer to my question.
Objection, Your Honor.
What is the basis for your objection, Ms. Alfonso?
Your Honor, my witness has the right to qualify her answers.
No, your witness is doesn't have the right to do anything but answer the question. And the question was asked as a yes or a no. The witness has not been answering the question, and Mrs. Sachdeva has been more than patient, probably more patient than I am. So having said that, I'm now directing the witness to answer the question. Your objection's overruled. Go ahead, please.
Yes, sir.
Dr. Hornby, I will re-ask my question. This ketamine was injected directly into your uncle's bloodstream?
I said yes, sir.
Even trace amounts of ketamine can be fatal?
Could be.
Especially in someone immunocompromised like Arthur?
I'm sorry, I didn't hear your question. Could you repeat?
Especially in someone immunocompromised like Arthur?
Yes.
Let's be clear here, doctor. You don't even know if your intern brought you the wrong syringe?
Could you repeat? I'm sorry. I really can't hear you. I'm sorry.
Of course, Dr. Hornby. Let's be clear. You don't even know if your intern brought you the wrong syringe.
I didn't double check the exact syringe that Finley gave me. I had only given the instructions.
You don't even know if Finley filled it with ketamine by accident or not?
I couldn't tell you for sure.
You don't even know if the syringe was cleaned in accordance with your hospital standards?
I found out later that it had been cleaned with chemical rinses. However, that wasn't known to me, and I didn't know at the time if that was the cause or not.
I would like a yes or no answer to my question. You don't even know if the syringe was cleaned in accordance with your hospital standards?
At the time, I did not know.
Do you think that it's possible that all these things mentioned above could have occurred?
I do.
But more than that, doctor, you think it's even probable?
That these things could have occurred?
Yes.
Yes, I believe that one of them had to have been the issue.
And due to this, you would consider something went wrong?
Of course, something went wrong, yes.
And maybe you shouldn't have trusted your intern that day.
I mean, I had to trust all of my interns with an assignment at one point, so
I would like a yes or no answer to my question, Dr. Hornby. I will re-ask. I would like a yes or no answer to my question. You shouldn't have trusted your intern that day?
I wouldn't say that I shouldn't have trusted them. I wouldn't say that.
And the thought of this haunts you at night, doesn't it, doctor?
That my uncle passed away, yes, it does.
Thank you. No further questions.
Okay, Ms. Alfonso, any redirect examination? Oh, well, did the witness leave? Oh, no, yes, she is. Okay, go ahead, Ms. Alfonso, any redirect examination?
Not at this time, Your Honor. We simply ask that our witness be excused.
Okay, yes, Dr. Hornby, you're excused. Thank you very much. Does the defense have any other witnesses?
Yes, Your Honor. The defense would like to call Riley Kwan to the stand.
Okay, please proceed, Mr. Sanchez.
Good evening, ma'am. Please say your name for the record.
Good evening, sir. My name is Riley Kwan.
And what is your current occupation?
Well, currently I work as an administrative coordinator at Lingfield Hospital of Tilly.
And how long have you had this job for?
I've been with Langford for 12 years. First as a nurse, then as a supervisor, and now as an administrative coordinator. I like to say I've been to everywhere except the operating room.
And what exactly do you do as the administrative coordinator?
My job is logistics and oversight. That means supervising rotation, signing off on intern hours, just making sure that all the paperwork in the hospital is up to date.
Now, Ms. Kwan, I want to talk a bit more about your place of work. And how would you describe Langford Hospital?
Well, Langford is a busy hospital. Even though we're not the biggest in Tilly, we take in more patients in our budget, as we should. To be honest, most of us work double shifts very often. It's safe to say that we are always running around at Langford. Even the interns have too much on their plate.
And as the administrative coordinator at the hospital, and based on what you observed, how would you describe the intern's qualifications?
Well, based on what I've seen, I would say that there's a range of experience levels. Some interns are great. Some shouldn't be anywhere near needle. But these interns are always supervised, though.
And how many interns do doctors have to supervise?
Well, I know that the standard is one attending to 3 interns on paper, but that becomes 1 to 6 when someone calls in sick. At the end of the day, our hospital relies on these interns. We need them to keep on running.
Now, Ms. Kwan, I want to talk more about the day of the incident. And what do you remember from February 16th, 2025?
Too much. Early on in the day, the hospital short 2 nurses, and the ER was backed up from a bus accident that morning. I was going mad trying to find replacements for the shorts and staff. And then that's when I remember later in the day at around 2, a clerk told me that Dr. Hornby's uncle had checked in.
And what had happened next?
Well, about 30 minutes after that, one of the orderlies told me that Hornby had finished the consult. I'd figured that it was the uncle since he had just checked in. But shortly after that, the cold call came through the intercom. I found out that there was a collapse outside the main entrance. Hearing that, I can say I was alarmed, but unfortunately at Langford, that's not too unusual.
And how so, Miss Kwan?
Well, Langford is a hospital. We've had people faint at check-in, out front, even in the cafeteria. But when I heard the name of Arthur Henley, I knew something serious had happened.
Okay, so what happened after the cold call came through?
I went downstairs immediately, but by the time I got there, they were bringing him on a stretcher. I couldn't go into the trauma bay since I'm not official medical staff, but I could see Hornby through the window doing chest compressions. I noticed that he looked pale to me.
Moving on, Miss Kwan, I want to talk about what you did after the incident because as the administrative coordinator, what exactly did you do?
After everything settled, I pulled the chart and a medication log to start the incident file. That's a part of my job whenever there's an unexpected death.
And what did this medication log show?
It showed Henley received lorazepam at 2:47 p.m., initiated by Finley under Dr. Hornby's supervision. Nothing too unusual, except 15 minutes later, the man was dead.
And aside from this medication log, did you review anything else, Miss Kwan?
Actually, yes. Later I saw the lab report and my stomach dropped. It showed ketamine in his system. Ketamine is a drug that doesn't slip in by accident unless something seriously went wrong.
And did anything else go wrong?
Yes, it's very possible. The autoclave in the ward had been broken for weeks. We were waiting on a part that never came.
Now, don't mind me asking, Miss Kwan, but what exactly is an autoclave?
Well, to keep it simple, an autoclave is a sterilization machine that uses extremely hot pressurized steam to clean medical instruments like syringes. It can remove any residual chemicals or substances that may have been left on that equipment.
And how did the hospital deal with the issue of not having a functioning autoclave?
Without the autoclave, we had to clean syringes manually with chemical solution instead of the heat cycle. We had to rinse them.
And would you recognize the syringe from the day of the incident if I were showed to?
Yes, I would.
Your Honor, let the record reflect that the tech for the defense will now be screen sharing what has been pre-marked as Exhibit 3. Your Honor, can you see the screen?
Yes, I can.
Ms. Kwan, what is this?
Well, it looks to be the syringe that Dr. Hornby had injected into Henley.
And is it a fair and accurate depiction?
Yes.
Has it been changed or altered in any way?
No, not to my knowledge.
Your Honor, barring any objections from the plaintiff, the defense now moves into evidence of what has been pre-marked as Exhibit 3.
Okay. Ms. Jiang, any objection?
No objections, Your Honor.
Okay, then Exhibit 3 is accepted into evidence. Continue, Mr. Sanchez.
Yes, Your Honor. So, Ms. Kwan, how well did the rinse of these syringes have to be?
Well, it had to be perfect. If it was too short, for example, residue from strong medication like ketamine can stay behind. And you can see how this begins to sound familiar.
And as the administrative coordinator of the hospital, did you do anything at all to fix the autoclave?
Yes, I really tried to get this part for the autoclave and get this fixed. I remember I emailed the faculty director 3 times about the autoclave before this incident. It was ridiculous.
And have you ever seen a hazard come from this?
Yes, at my experience at the hospital, I personally seen someone pass away from large residue remains from ketamine in a syringe. So, yes, in my personal experience, this is hazardous.
Your Honor, let the record reflect that the tech for the defense will now be ending the screen share. So, Ms. Kwan, what were your observations of Langford Hospital?
Well, Langford is a good place and a good hospital, but it's held together by duct tape. We're always short on equipment, short on staff, but one thing I can say for sure is that the administration is safe.
And what exactly do you mean by the administration is safe, Ms. Kwan?
When something goes wrong, I notice the blame lands on whoever touched the syringe last, but hospitals are more like a chain reaction. If one single small thing goes wrong down the line, everything can come crashing down. with the nature of our hospital and any hospital really, everyone is always constantly running on fumes.
Thank you, Ms. Kwan. No further questions, Your Honor.
Okay, thank you, Mrs. Sanchez. Ms. Jiang, cross-examination.
Yes, Your Honor. Good evening, ma'am.
Good evening.
I'd like to begin by talking about some problems the hospital faced leading up to the day of the incident. Now, the autoclave machine had been malfunctioning for weeks, hadn't it?
Yes, it was malfunctioning. We were waiting on a part that never came.
So that meant equipment sterilization wasn't up to standard for that period of time?
Yes, that's true. Instead of using the heat cycle, we had to use chemical solution. We had to rinse them manually.
Right, you had to rinse them manually, so unless it was cleaned perfectly, contaminated residue could still linger.
Yes, that's correct.
And you had already emailed the administration 3 times about this.
Yes, I emailed the faculty director. It was ridiculous, yes.
It was ridiculous. Well, let's talk about why. They never replied, right?
Yes, that is correct.
However, you never tried calling them?
No, but honestly, the hospital is busy. It's a busy environment. I'm a busy person, so I unfortunately did not get to it, no.
Ma'am, you may re-clarify this on redirect with your attorney, but for now, I'd like a yes or no to my question.
Objection, Your Honor. I believe my witness has the opportunity to back up their answer. Therefore, they should not be limited to a yes or no response.
I want the witness to give a yes or no response. So therefore, your objection, Mrs. Sanchez, is overruled. Go ahead, Ms. Jiang.
Yes, Your
Why
Honor.
don't you re-ask the question?
Miss Kwan, you never tried calling them?
No, I did not.
Now, I'd like to shift to the day of the incident, February 16th, 2025. At around 2 p.m., you were notified that Arthur Henley had checked in, right?
Yes, that's correct.
Now, Arthur Henley is Dr. Hornby's uncle,
Yes, that's correct.
and family treatment is discouraged in your field.
Correct. It is discouraged, but we were extremely backed up that day, so it just seemed easier. But yeah, so it is discouraged.
Yet, despite this, you still let Arthur go through with the treatment?
I mean, correct. Yes, that's correct. Dr. Hornby is a senior physician. I mean, it was just mild anxiety. It seemed easier.
Ma'am, I'd like a yes or no to my question. You still let Arthur go through with the treatment?
Yes,
And you weren't actually in the room when his treatment was delivered.
that is correct.
You didn't watch anyone prepare the syringe?
No.
Let's talk about who actually prepared the syringe. It was an intern named Finley Riveras, correct?
Yes, that is correct.
And Dr. Hornby was the attending supervisor for Riveras that day?
Yes.
Now, after the incident had occurred, Hornby told you that he should have checked it himself,
Objection,
correct?
Your Honor. Pursuant to Rule 801 hearsay, may I be heard?
Yes, go ahead.
Hearsay is any out-of-court statement offered to prove the truth of the matter asserted. Opposing counsel just referenced a statement made by Dr. Hornby that was referenced to Ms. Kwan, and I believe they're trying to show the true value of these statements. Therefore, it falls under 801 hearsay and is therefore inadmissible.
Okay, Ms. Jiang, I'm listening. What's the answer to that?
Your Honor, like opposing counsel said, this statement was made by Elias Hornby, the opposing party, the party opponent in this case. So this statement falls under hearsay exception 801D2.
801D2. Mr. Sanchez, back in the olden days when I was in law school, we used to call that a party admission. What's the answer to that?
Your Honor, we still believe it's an out-of-court statement, but if they are going to use this exception, then it should be allowed.
Okay. Honesty is a good policy. The objection's overruled. Continue, Ms. Jiang.
Now back to my question, Miss Kwan. After the incident had occurred, Hornby told you that he should have checked it himself, correct?
Yes, that's correct, but I just think that Hornby was trying to make sense of the whole situation. But yes.
Ma'am, oh, all right. Ma'am, I'm not asking you about what Hornby thought. I'm asking you that he told you that he should have checked it himself.
Yes, that's correct.
He repeated that not once, but multiple times?
Yes, that is true.
Thank you. No further questions, Your Honor.
Mr. Sanchez, any redirect examination?
None at this time, Your Honor.
Okay, with that, Ms. Kwan, you're excused. Thank you very much. Does the defense have any other witnesses?
No, Your Honor. At this time, the defense rests their case in chief.
Okay, are we ready to proceed into closing arguments?
The defense stands ready, Your Honor.
Okay, very good. So with that, let's first hear from plaintiff. Mrs. Sachdeva, please proceed.
The system doesn't treat the patient. Dr. Hornby did, and she chose to look away. A system is only as safe as the person running it, and Dr. Hornby was certainly not safe that day. Members of the jury, let me remind you of our three key facts in this case: the breach, the blame, the behavior. On February 16, 2025, Arthur Henley comes in with his best friend, Andy Parr, to the hospital. It's a routine checkup done by a family member, Elias Hornby. Neither of them was expecting anything to go wrong. But 5 minutes after this injection, Arthur Henley falls down and is pronounced dead later that day, not even half an hour later. This is why we, the plaintiff, are suing Elias Hornby for medical malpractice. Members of the jury, we believe that we have shown this case by a preponderance of the evidence. We have shown this case by a preponderance of the evidence with three key facts: the breach, the blame, and the behavior. The defendant owed my client a duty of care, breached this duty, and this breach was the proximate cause of my client's wrongful death. First, the breach. The evidence showed that Elias Hornby breached his medical practices. He said to himself during an interview that he should have double-checked. He did not double-check the syringe. He never communicated with the intern, and he himself injected his patient with ketamine. You also heard how Arthur Henley was supposed to be injected with lorazepam. Instead, they find ketamine, a dangerous drug, 6 to 12 times the lethal dose. When she came to receive treatment, she ended up dying. It was the defendant's responsibility to confirm the contents of the syringe, but she didn't. You heard on cross-examination that she didn't even double-check. You heard on cross-examination Dr. Hornby admitting that she didn't even know if the intern brought you the wrong syringe. Members of the jury, this proves Dr. Hornby was directly responsible for the decedent's wrongful death when administering the injection to my client. She had a duty, and that duty was breached. Second, the blame. You've heard how Finley Rivera's, the intern, was the one who handled the syringe, not the defendant. Your Honor, you don't have to take my word for it. On cross-examination, the defendant himself admitted that the administration of treatment is their responsibility as the physician. Now, was it possible that the bottles were mislabeled? Sure. Is it possible that it's the intern's mistake? Maybe. Was it in the end Elias Hornby's responsibility as a doctor to check the contents of that syringe? Absolutely. In this case, as the leading physician in charge, the blame falls entirely on her, whether it was not intentional. Finally, the behavior. Specifically, the defendant's. She was drowning in medical school debt, and Arthur was the one helping her stay afloat. but you heard how Arthur held this debt over Dr. Hornby's head, sparking bitterness and resentment. Now, something happened earlier in today's trial. It stuck out to me. It stuck out to me so much that I wrote it down on this legal pad. At the end of the cross-examination of Dr. Hornby, I asked Dr. Hornby if she should have double-checked the syringe. She said yes. I asked Dr. Hornby if she shouldn't have trusted her intern that day. She said yes. I asked Dr. Hornby if the thought still haunts her to this day. She said yes. Key questions and key answers that Dr. Hornby should have done. And Your Honor, that is emblematic of the entire defense case today. It is emblematic because not even opposing counsel knows the answers to these questions, and neither does Dr. Hornby. The entire case relies on Dr. Hornby knowing the answers to these three questions. Ladies and gentlemen of the jury, this case is about a careless physician, or even worse, a murderous one, and an innocent man's wrongful death. Whether by an intentional act of malice or a reckless mistake, the evidence showed that Dr. Elias Hornby failed to uphold her standard of care. This is why, at the end of today's trial, my co-counsel and I will ask you to find her liable for her actions. Because when a doctor betrays her duty, the case boils down to three things: the breach, the blame, the behavior. Thank you.
Thank you, Mr. Sachdeva. Very good. Let us now hear from the defense. Please proceed, Ms. Alfonso.
Yes, Your Honor. May it please the court, Your Honor, opposing counsel, members of the jury. Mr. Sachdeva wants you to believe that this tragic event stems from a breach, a blame, and behavior. However, the simple truth of the matter is that the plaintiff's whole case is about misplaced blame over the negligent behavior of an intern, but there was never a breach of duty by Dr. Hornsby because she never failed her patient. The system did. When Arthur walked into that hospital, he trusted that system would protect him. Dr. Hornby, a physician of 13 years, trusted that system would protect her because accidents happen, but she never failed her patient. The system did. Today, the plaintiff has decided to take on a suit of medical malpractice and wrongful death. And what that means is that they took on the burden to prove to you today every element of these claims by a preponderance of the evidence. And to prove medical malpractice, the plaintiff had to prove three elements. One, that Dr. Elias Hornby owed Arthur Henley a duty to meet the applicable standard of medical care. Two, that Dr. Hornby breached that standard of care. And three, that breach was the proximate cause of harm done to Henley. And to prove wrongful death to you, the plaintiff had to prove three more elements. One, that Arthur Henley died. Two, that his death was caused by the wrongful act of the defendant. And three, that the plaintiff suffered a compensable loss as a result. Ladies and gentlemen, I'd like to remind you that it was the plaintiff, and only the plaintiff, who held the burden of proving these elements to you by a preponderance of the evidence. And they failed to meet that burden. Yes, Dr. Hornby had a duty of care, and she met it. The plaintiff failed to prove to you today that she breached that duty because you heard it today on that stand. From a licensed physician of 13 years, Dr. Hornby treated her uncle at least 8 times with no issues. Do not let the plaintiff confuse you. Doctors are not required to ensure a successful outcome for a patient, and an error in judgment is not automatically a breach in the standard of care. That is the law in Tilly, and that is the truth of today's case, because accidents happen, and it's unfortunate, but it does not mean negligence. When faced with the choice to make the right decision to fire Riveros, who filled the syringe with the wrong substance, Dr. Hornby tried, but the hospital chose to keep Rivera's despite concerns. She never failed her patient. The system did. Because the plaintiff not only failed to prove to you a breach, they also failed to prove to you causation. Through today's testimony, you heard from Riley Kwan and Dr. Hornby that the hospital was understaffed, assigning multiple interns to one attending, underfunded, and the autoclave was broken. The system was relying on manual chemical rinses, something Dr. Hornby did not know was happening. There was no way Hornby could have reasonably known about the system failures, because neither did the plaintiff's expert, Dr. Alex Zuzak, because Dr. Zuzak did not consider this malfunction or include it in their conclusion. In the jurisdiction of Tilly, it is established through case law that you, members of the jury, may only evaluate a doctor based on the information they actually had or reasonably should have had. Remember that. And we sympathize with Andy Parr. Losing a friend is difficult. But she told you herself on that stand during cross-examination. She never liked Dr. Hornby, and she didn't actually know what was happening behind the scenes at the hospital. The plaintiff failed to prove to you medical malpractice, and without medical malpractice, there is no wrongful death. The fact of today's case is that this was not negligence, simply a tragic accident, because she never failed her patient. The system did. The plaintiff failed to meet their burden. They could not prove to you medical malpractice, and they could not prove to you wrongful death, because an accident is not negligence. Which is why we ask you, on behalf of the defense, on behalf of Dr. Elias Hornby, return the only verdict that is supported by both the law and the evidence. A verdict of finding Dr. Hornby not liable. Thank you.
Thank you, Ms. Alfonso. Mr. Sachdeva, I saw the timing, and your side shortchanged you by a few seconds compared to the other side. So typically what I do when I see different times is I tend to split the difference. Therefore, you have 34 seconds by my calculation to give your rebuttal. So the timekeeper should adjust for 34 seconds. Mr. Sachdeva, whenever you're ready, please proceed.
Blaming the system is an excuse. Failing the patient is a fact. Opposing counsel wants you to believe the breach, blame, and behavior was not relevant because of the system. But let me remind you that the system is just a net, and Dr. Hornby was the one who let the patient fall through the holes. Dr. Hornby's actions of not checking the syringe, not double checking the syringe that was filled with 10 to 12 times the amount of ketamine instead of lorazepam, and trusting her inexperienced intern, Finley Rivera's, directly caused the death of Arthur Henley. We believe that our case proved medical malpractice and wrongful death of Arthur Henley at the hands of Dr. Hornby. Doctors don't have to guarantee success, but they have to guarantee safety. And Dr. Hornby was certainly not safe. He was negligent. And for this reason, I will ask that you find Dr.
It looks like your time was up here, if I'm reading correctly. So thank you very much, Mrs. Sachdeva. At this point, I would ask everybody to please put on your screens so we could see who we're looking at and scoring, and we could finalize our paperwork. Okay?
Hey guys, amazing job. You guys are obviously very, very talented and very, very well prepared. So you guys did a very, very good job. And yeah, give yourselves a round of applause for that. I would say my favorite part of this trial would be the objection battles. I love the rules of evidence. I love objections. So I was very, very I really appreciated all the objection battles. One thing I could say that y'all could improve on could be utilizing pauses. I think that pauses add a lot more to essentially every part of the trial. Statements, directs, crosses. Before you start a statement, give it a little pause. May it please the court. It helps center yourself and it gives the jury or the judge the illusion that you're very confident, which is really good for your case. And when it's for directs and crosses, right before you end, right before, thank you, I have nothing further, Your Honor, do a little pause. Let it sink in. At the end of your cross, the strongest question, you got the witness to say, oh, yes, I should have checked the syringe. Pause. Thank you. I have nothing further, Your Honor. And that helps it sink in and really gives it the weight of how important the information you're giving the jury is. But overall, very, very good job. I would not have wanted to go against you when I was back in high school. You guys are very, very talented. So good job. William?
Yeah, great job, everyone. I completely agree with everything Karen said, so congratulations. I think just one thing I really liked about both sides were how great the speeches were. I think opening and closing statements were all absolutely fantastic. I think they made very clear what are you chasing. For the plaintiff, it's the breach, the blame the behavior, and for the defense, it's to blame the system, not the individual doctor. But I think one thing that I would really like to have heard a little bit more was during the examinations. If you could just, keep in mind that these are your main arguments and just try to bring them out in the examinations as well as in the statements. I think the storytelling for both sides would have been a lot more effective. So I think one way to do that is just to signpost more, like say you want to ask about this certain point and make it clear why this certain point, this pocket of questioning helps further the overarching arguments that you made in the opening statement. So you can, tie all these facts that you brought out nicely, neatly in the closing statements. But other than that, I don't really have much to say. It was a really, really good round. So thank you, everyone.
Okay. I thought, I'm not sure if Judge Williams said this in a prior round that I judged, but it's probably applicable here. And if he didn't say it, somebody else said it. And that is, it's helpful to read the judge and figure out, was that you, William, who said that previously to me? Yeah, and figure out where the judge is going. Okay. Sometimes, and I agree. I think that the objections, I like when people cite the rules. I like when people have things, but sometimes you got, Ms. Alfonso, you're getting a little carried away. You threw one type of objection and then another one and so on. And I'm trying to, I want to give the other side a chance to respond because that's how it shows it. But, then, and one of those might actually be a winner. And in fact, it sometimes gets a little bit confusing. Rule 403, as I point out, is seldom granted. You've got to have substantially outweigh, by the prejudicial effect. So that's not typically a winner. Now, this business with the koi pond, again, that got confusing. It shouldn't have been confusing. I knew where it was all going, and I understood. I've heard the argument at a previous trial. So it's not that it couldn't have gotten in, but it was presented, I think, in too confusing a way. I agree with everything that was said previously. I thought the comments, the openings and closings were very good. Watch for speculation. There was some things that were being speculated to that nobody was objecting on the grounds of speculation. And nobody seemed to want to avail themselves of redirect examination. And redirect examination is good to rehabilitate your witness. And more often than not, people's score goes up when they do a proper redirect examination. So since this is a competition and you want to maximize your score, you're not getting, I promise you, there is no points when you say, my witness be excused. That does not gain any points for anybody. But if you do a good redirect examination, and There was, I made a note, it was the second defense witness. I made a note. There could have been a redirect examination there that I thought would have been helpful. And you also, you got to remember you're talking to a jury. I think it was Mr. Sachdeva in his presentation said something about being emblematic. Okay. While you're all bright students, I assure you, okay, that 4 out of every, 12 jurors are not going to know what emblematic means. Okay. And you are talking to a jury. So you want to remember that. I served on a jury once, probably one of the most instructive 3 days I ever had as a lawyer, is because you get to see what people listen and pay close attention to and what's important to them. They like seeing a Dr. Zuzak. I thought he was a very, cheery witness. But then in the end, he started off really, really good, and it was a good back and forth, on direct examination, but then he got, squished on the cross examination. So, that's when, Dr. Zuzak and his cheeriness should have become Dr. Zuzak and his toughness. And he should have been a little bit more forceful in response to these things. But, a lot of it is, listening closely, and and I think pretty much, as I said, this was a good round. I mean, I've done this case a couple times, and this was very enjoyable. I think everybody did a really good job. Does anyone have any questions for us about anything that was said? Terrific.
All right, seeing no questions, time for me to give you some answers. We're going to do 2 things. First, recognize MVPs in this round, and then second, say who's moving on to finals. MVPs is voted on by your judges. There was a split decision for both attorney and witness. But winning the attorney MVP decision, mental drum roll, please. From the defense, Miss Isabel Alfonso. Congratulations.
Thank you.
There was also a split decision for the top witness in this round. Winning the split decision, that is Amanda Puentes. Congratulations to Amanda Puentes. We now go to the results. This was not a split decision on results. However, the margins were single digits on every ballot. Congratulations to both teams, but moving on to the final round is the defense. We are going to give the written feedback to you ASAP in the chat, but we're stopping the recording now. Best of luck in finals.